In this video, we're going to review some of the rules that we've learned concerning remedies. We'll see that the plaintiff has a large number of different possible choices for remedies, but that many of these choices are subject to certain limitations. We'll also then talk about the pattern of argumentation that may arise in a case where a plaintiff seeks particular remedies. Let's start by talking about specific performance. A court grants the remedy of specific performance by ordering the defendant to carry out the promise that the defendant made. A court may deny specific performance for a variety of reasons. We've looked at two of these reasons, but there are many others. The first reason is that a court will deny specific performance if damages would be an adequate remedy. In determining adequacy, courts consider whether damages can be proved with reasonable certainty, whether the plaintiff might obtain a substitute performance, and whether the plaintiff could collect an award of damages. By tradition, courts have held that damages are not an adequate remedy for a breach of a contract to sell land. In addition, a court will deny specific performance if at the time the contract was made, the terms of the contract were unfair or the consideration for the defendant's promise was grossly inadequate. The promise still may be enforceable if the plaintiff wants damages, but the plaintiff can't get specific performance. Now let's talk about expectation damages. The general rule is that the plaintiff has a right to expectation damages, which is the amount of money necessary to put the plaintiff in the position the plaintiff would have been in if the defendant had not breached the contract. Expectation damages equal the plaintiff's loss in value plus other loss, minus the plaintiff's costs avoided, and minus other loss avoided. Now let's talk about the definitions of these terms. Loss in value equals the difference between what the defendant promised and what the defendant actually delivered. 20th Century Fox, the loss in value was $750,000 because 20th Century Fox promised to pay Parker that amount of money and it actually paid her nothing. Other loss includes any consequential or incidental harm caused by the defendant's breach. For example, in Hadley v. Baxendale, the other loss was the profit lost while the factory was shut down because of the delay in delivering the mill shaft. Costs avoided equals the difference between the cost the plaintiff expected in performing and the cost the plaintiff actually incurred. For example, in Sullivan v. O'Connor, the cost avoided was zero because Mrs. Sullivan expected to pay Dr. O'Connor's fee, and she paid the fee. If she hadn't paid the fee, though, that fee would have to be subtracted from her expectation damages. Other loss avoided equals any losses that could have been that would have been incurred incident to or consequent to the plaintiff's performance, which were not incurred because of the breach. In Sullivan v. O'Connor, for example, the other loss avoided was zero because Mrs. Sullivan expected to undergo 2 operations and pay the hospital fees incident to her performance, and she did those things. But if Dr. O'Connor had simply refused to do the operation, well, then she wouldn't have had to undergo the pain and suffering with those operations or pay the hospital fees, and so those other losses would be avoided. Now, there are 4 very important limitations that apply to expectation damages. The first is that the plaintiff may not recover damages that could have been avoided without undue risk, burden, or humiliation. An example of that in the Rockingham County v. Luton Bridge case. Luton Bridge had to stop performance. The plaintiff may have to make substitute arrangements, such as undertaking comparable employment. That was the issue that was discussed in Parker v. 20th Century Fox. Second one has to do with incomplete or defective performance. In cases of incomplete or defective performance, the plaintiff always may recover the loss and the market value to the property. As an alternative, the plaintiff may recover the cost to complete or remedy the defect unless that cost is grossly disproportionate to the loss, to the probable loss in value to the plaintiff. Unforeseeability. The plaintiff may not recover damages for losses that were not foreseeable at the time the contract was made. Losses are foreseeable, according to the courts, if they arise in the ordinary course of events or if the defendant had notice of the special circumstances giving rise to them. Hadley v. Baxendale, the problem was that the shipping company didn't know that the mill would be shut down if it delivered the package late. Uncertainty is the final limitation, and that is that the plaintiff cannot recover damages that the plaintiff cannot prove with reasonable certainty. The plaintiff might have a difficulty showing the fact of loss, or the extent of loss, or the measurement, the dollar value of the loss. What about reliance damages? Well, as an alternative to expectation damages, the plaintiff may recover reliance damages, which is the amount of money necessary to put the plaintiff in the same position the plaintiff would have been in if the contract had not been made. Nominal damages are an alternative. If the plaintiff proves the defendant breached the contract but cannot prove the damages, perhaps because they cannot be shown with reasonable certainty, a court may award the plaintiff nominal damages. Traditionally, these have been either $1 or 6 cents. Now, what about liquidated damages? Well, the court may award the plaintiff liquidated damages that the parties stipulated in the contract. But there are two limitations. The first is that a court will not enforce a stipulated measure of damages that is unreasonably large in comparison to the actual or anticipated loss. The court will describe that amount of damages as a penalty, and it will be unenforceable. In addition, a court will not enforce a stipulated remedy that is unconscionably small. So, for example, in Henningsen v. Bluefield Motors, the stipulated remedy was that Mrs. Henningsen got a new steering wheel, but the court refused to enforce that remedy. Although the court described that as public policy, modern courts would probably describe it as a problem of unconscionability. Now, what is the pattern of argumentation that arises in remedy cases? Well, the plaintiff starts out with a simple claim that the defendant made a promise and didn't keep it. The defendant then might raise a number of defenses, such as there was no offer and acceptance, or there was no consideration, or I've kept the promise. The defendant then might make a variety of replies to those defenses. Maybe the plaintiff will succeed and maybe the plaintiff won't. If the plaintiff does succeed, then the plaintiff may seek to obtain certain remedies. One possible remedy would be liquidated damages. The plaintiff will say, well, if the promise is enforceable, the court should order the defendant to pay the amount of damages stipulated in the contract. The defendant, however, may object, saying that the liquidated damage measurement is unreasonably large in relation to both actual and anticipated damages, and therefore cannot be enforced because it's a penalty. The plaintiff also might seek specific performance as an alternative. If liquidated damages are not available, the court should order the specific performance of the defendant's promise. Here the defendant has two responses. The defendant may say, well, damages are adequate. The plaintiff is not entitled to specific performance because damages would be an adequate remedy. Secondly, the defendant might say that the plaintiff is not entitled to specific performance because the bargain was unfair at the time it was made. We saw an example of that argument in McKinnon v. Benedict and the Tuckwiller v. Tuckwiller case. In McKinnon v. Benedict, the court refused to grant specific performance because it found that the defendant had not received enough consideration for his promise not to build the campsite closer to the plaintiff's property. Expectation damages. Well, if specific performance is unavailable, the plaintiff may say that the defendant should pay expectation damages. The plaintiff will then have to say that the defendant's breach has made me worse off because, and then the plaintiff will describe the loss in value and the other loss, although I grudgingly admit that I'm better off because, and then the plaintiff will describe the costs avoided and other loss avoided. Expectation damages will equal the difference between these two figures. Now, the defendant will raise a number of responses based on the limitations that we talked about. First, the defendant will say the court should reduce the expectation damages claim based on avoidability. The defendant will argue that the plaintiff has overstated the other loss because some of that loss could have been avoided. The defendant also may argue that the plaintiff has understated the costs avoided because the plaintiff could have avoided some of the additional costs, either by ceasing performance or by making substitute arrangements. The defendant also may argue that the court should reduce the expectation damages claimed for an incomplete or defective performance. For example, the defendant may say that for loss in value, the plaintiff has attempted to use the cost to complete a remedy, but this amount is grossly disproportionate to the probable loss in value to the plaintiff. Finally, the defendant may argue, the defendant may argue that the court should reduce the expectation damages claimed because the loss in value was not foreseeable at the time the contract was made, because the damages did not arise in the ordinary course of events, and because the defendant did not have notice of the special circumstances giving rise to the damages. Finally, the defendant may argue that the court should reduce the expectation damages because the plaintiff cannot prove the loss in value of the other loss with reasonable certainty. We saw examples of that argument in both the Collapse v. Fox Amusement cases and the Fair v. Village Plaza cases. If the plaintiff cannot get expectation damages, the plaintiff might seek reliance damages as an alternative. Here the plaintiff will have to state the reasons that the plaintiff is worse off than if the contract had never been made. The final option might be nominal damages. If no other remedy is available, the defendant should at least pay nominal damages. Those are some of the rules that we've learned and the pattern of argumentation that we've seen when the parties seek remedies. Thank you very much for listening.